Thank you very much. We'll open with questions then, and I'll start the call with Senator Roberts.
Thank you, Chair, and thank you for appearing again tonight. We're getting pretty familiar, Ms Booth. My questions are pretty simple tonight. What are the total number of matters being investigated in the coal sector? I'm particularly interested in those matters that came out of the One Nation analysis in which labour hire payments to coal workers were and are below what would be an award casualised rate if such a thing exists. It doesn't, but if it did. Can you confirm for me again how many matters are in that category? My recollection is that there were around 14 individuals.
Senator, as at the 26th of September of this year, we had 33 cases under investigation and had finalised an additional 13 cases in the black coal mining industry. That is in Mr Campbell's jurisdiction, so I will pass to him.
Senator, I'll obviously assist you. Michael Campbell, Group Manager of Operations. I'll obviously assist you with questioning on this subject. We have Steve Ronson here to assist with detail as well, given the nature of your questions. So happy to go into any detail you like.
Well, I'll let you get on with the cases, resolving the cases and the complaints.
Works for me.
Sorry?
It works for me.
Good. Can you give me a rundown on the number of entities and type that have been consulted in relation to those matters, specifically the labour hire companies and the mine owners perhaps, and what sort of feedback and cooperation you have received?
Senator Steve Ronson, Executive Director, Fair Work Ombudsman. Of those 33 cases that Ms Booth's referred to, there's 25 employing entities. So there's 25 different companies, if you like, that are being investigated.
Thank you. Ms Booth, can I come back to you? What was the total number you said? I thought it was
33.
33, I thought you said
under
3.
investigation.
Okay, thank you. Now, I know that the analysis we published states that there are large underpayments based on a comparison to what would or should be a casualised award rate, but there's a trick because the coal award does not have casualised rates, as we've discussed at length. That being the case, are you investigating the matters and assessing whether underpayments have occurred compared to what would be a casual coal award rate if such a rate existed?
Turn to Mr Campbell to answer that.
Well, yeah.
Good evening, Senator Roberts. It's Rachel Volsky, Chief Counsel. As I think we've discussed on a number of occasions, these issues and some of the complexities that arise in relation to the absence of casual operational roles under the award. So what we've done is proceed on the basis of the information before us and determining what, if any, underpayments might be payable in relation to each of those matters that we're investigating.
So what would be the base rate, so to speak? Because you're talking about casual?
Well, if there's an enterprise agreement in operation in relation to a particular employee, then it would be the enterprise agreement that nationally we would be looking at, and obviously if there wasn't, then it would be, there might be contracts of employment, etc. as well. It's obviously going to depend on the particular circumstances. So
what I'm getting to is, would you compare it with the base rate of permanent employees doing the same job and add 25% to take into account the lack of other conditions of employment?
So, Senator, as we've spoken about before, because the award doesn't provide for that, we would, for those employees, which I think mostly in that cohort had enterprise agreements relevant to their employment, that would be the document that we would look to test, I guess, against any potential underpayments.
So even if the enterprise agreement that we think was not fair, that would still be the base rate that you would compare it to?
So, Senator, as we've spoken about previously, you know, as the independent regulator, we apply the law as it stands, and where agreements have been made and approved by the Fair Work Commission as valid enterprise agreements, then those are the industrial instruments that we will use to determine any underpayments.
So if the Fair Work Commission has approved an enterprise agreement that is grossly underpaid compared to the award, you would go with the enterprise agreement?
Senator, I can't comment on the fairness or otherwise But what I would say is where it has been lawfully made and is in operation for the particular period of time that might be in question for a particular employee, then that's the instrument that we test those underpayments against.
Have you identified instances where labour hire casual employees have been paid below the full-time award rate? If so, that would clearly constitute underpayment.
Senator, I'm not aware that that's the case so far, but I'm happy to take that on notice just to double check. But I'm not aware.
Thank you. Ongoing underpayments is next topic. We have been following the same job, same pay applications in the coal sector, Minister, which on our observation is a very slow process. By the way, I led the development of the same work, same job, same pay in the Senate. Given that there are a significant number of coal operations not yet subject to the same job, same pay regime, we would assess, that's One Nation would assess, that there are still large numbers of casual labour hire coal miners that continue to be underpaid when compared with the casualised award rate. Would you concur with that assessment? I guess you would not.
Senator, I think the best way of answering that question would be what we've tried to do in the course of this investigation is to heighten awareness of our investigation. We have a dedicated email address just specifically for these cases alone. So anyone who's working in the sector or worked in the sector can request our assistance. And yet, as we've explained, I suppose each case will fall on its own merits. So we investigate each case as to what we find. We follow the evidence in that particular case.
So at the nub of this issue from the very start has been the claim by many casual coal miners, and I agree with them entirely, so do some experts in industrial relations, that the enterprise agreements in which they're working are dodgy. They're grossly under the award rate. But what you're saying is that's become the new benchmark. That's what I got out of Ms. Volker.
What we're saying is, as Ms. Volker put, is that we'll apply the law as it is, and if the enterprise agreement is in place for that particular worker, that's what we apply.
So you don't look at the roots of the enterprise agreement being below the award rate, lack of casual premium?
We'll look to see whether the enterprise agreement's been approved by the Fair Work Commission, and if it has, and it's a valid industrial instrument and it's operative, then we apply.
So you won't look into whether or not it passed the boot test?
No.
Given that the 33 matters we're focused on and you're investigating are of coal miners who have worked across a range of labour hire companies and a range of mines, would it be fair to say that the numbers of labour hire coal miners who have potentially been underpaid is significant, probably very significant? That is, that large numbers of coal miners worked and are continuing to work under exactly the industrial instruments of the individuals you're investigating. Our estimate is that the number would easily exceed 5,000, possibly 10,000. Would that be a reasonable guess?
I think, Senator, the premise of that question is something that we wouldn't agree with for the reasons that we've spoken about, and that is where there are enterprise agreements that applied and were validly approved by the Commission, then that is the document or instrument that we use to determine whether or not there have been underpayments. I think the other thing, and I know we've spoken about this previously, it's not necessarily the case that because the award doesn't provide for operational casual roles, that necessarily means that a particular employee would therefore be full-time. It might, for example, be that they are award-free, in which case their entitlements are by reference to the national minimum wage, for example. Another outcome might be a technical breach of the award that doesn't necessarily carry consequences as well. But I think, as we spoke about previously as well, the original 15A definition of casual employment that was inserted, I think, back in 2021, it applied with retrospective application, which was close to a designation approach to casual, and applied retrospectively, I think, including and would capture many of the historical complainants in this particular cohort that we're talking about.
So it seems to me that rather than miners getting justice for a trick that was pulled on them by the mine owner, the labour hire firm, which includes, in one case, an Australian offshoot of the world's largest labour hire firm, Recruit Holdings, from Japan, and the trick used by the mining division of the CFMEU, which is now back to being the Mining and Energy Union. Because of that trick, you're going to endorse it because they came up with a Fair Work Commission approved document.
Well, I think, Senator, we've also spoken previously about, who has standing to determine or, challenge whether or not an agreement has been validly approved. It's somebody who's aggrieved by that, and that doesn't extend to the Fair Work Ombudsman. Certainly it would be open to another party if they so wish to, challenge that.
Good luck with getting a law case cheaply in this country. We're aware that in your investigations that the Fair Work Ombudsman has a 6-year time limit restriction on being able to litigate to require compensation for underpayment. You've indicated, Ms Booth, in prior Senate estimates hearings that you have not restricted your investigations to the 6-year limit but have gone back much further. Is that correct?
That is the recollection of the evidence that we gave, Mr.
Yep.
Yeah,
that is correct, Senator.
Thank you. I think we've discussed in these hearings in the past that the underpayment that we have assessed has occurred because of the absence of a casualised rate in the coal award. We've discussed that to some extent. I'd like to look at it from another angle. Assuming that your investigation find the practical evidence in the 33 matters you are investigating, that supports our analysis. I assume that there may be legal difficulties in successfully prosecuting for compensation because of this legal trick, which is what I'm hearing now. That is, that it may be legally complex to have the courts agree that underpayments were illegal. Is it that underpaid casual labour hire coal miners are victims of a legal trick? Could that be a reasonable point of view?
I don't think that would come to that view, Senator. We wouldn't make a decision around the enforcement outcome until we've completed the
Around what? Sorry?
We wouldn't make a decision about the enforcement outcome we'd seek to impose in a certain circumstance until the conclusion of investigation. The statute of limitations we've talked about previously goes to the enforcement by way of litigation, for example, but there are other ways that we can seek to resolve a historical matter, which is also something we've discussed before, where we've found evidence of that contravention or an enforceable entitlement. So we haven't got to that point in these matters. So it remains open to us to consider how we will resolve them.
Thank you. Would the Fair Work Ombudsman task of seeking compensation be more straightforward if legislation existed that resolved the legal trick? We refer to clarifying that casualised labour hire coal miners should be and should have been paid 25% more than the full-time rate under the coal award. Yes or no? Would legislation make it easier?
I don't think we've got an opinion on that, Senator.
I think you're asking us if the law was different, would we apply the different law?
Well, I'll ask the Minister. Minister, we congratulate the government on eventually requesting the Fair Work Ombudsman to investigate gross underpayments of casual labour hire coal miners. It's taken about six and a half years. The investigations from the Fair Work Ombudsman to date appear to be heading in a direction that underpayment that we assessed were occurring may be confirmed on the evidence of the cases being investigated by the Fair Work Ombudsman. Further, it is likely, we believe, that any potential compensation may be legally difficult to enforce, which is what I'm hearing, because of a trick using enterprise agreements to get around the fact that in the coal award, the Black Coal Mining Industry Award does not allow for a casual rate for comparative purposes. It's our view that the most likely way to attain justice for casualised labour hire coal would be to have legislation that resolved the legal trick we refer to, clarifying that casualised labour hire coal miners should be and should have been paid at least 25% more than the full-time rate under the award. Assuming that the evidence from the Fair Work Ombudsman is forthcoming that supports the underpayment analysis, would the government be interested in considering such legislation for wage justice for these coal miners? If so, One Nation would be very keen to work with the government on such legislation and to lend their full support. Would the government consider that?
Thanks, Senator Roberts. The government has passed a suite of reforms to our workplace laws to get wages moving in this country, including the closing the loopholes legislation that established the same job, same pay principles, the better jobs, better pay legislation. We've improved rights for casuals. We've reinvigorated bargaining. We've done a lot of work to close the gender pay gap. We're really focused on improving the rights of Australians to be paid fairly for the work that they do. You're referring to matters that I think are best addressed by the team that's at the bench in terms of matters that the Fair Work Ombudsman has apparently been investigating.
They're not allowed to talk about policy and legislation. So that's what I'm asking.
You've referred, I think, in your question, Senator Roberts, to a report that may be coming. Is that correct?
Yes, we haven't concluded the investigation at this time.
Okay. You talk about rights, Minister. Clearly this, when you compare the people on a dodgy enterprise agreement compared with the Black Coal Mining Industry Award base rate plus 25% casual loading, is Australia's largest wage theft case, and that means workers have been betrayed, because this has been passed by the signed off by the Mining and Energy Union, or the CFMEU mining division, by the labour hire companies, including the largest in the world, by mine owners and the Fair Work Commission. So workers have got no protection whatsoever. If this goes through, workers have got no protection. There are thousands of them in central Queensland and Hunter Valley. It's blatant exploitation. Will the government step in? Subject to the report.
From a government perspective, it seems appropriate to wait for the report of the Fair Work Ombudsman and give it due consideration when the report's concluded.
Thank you, Minister. Thank you, Chair.
Thank you.